Hi everybody, welcome back to another Kingsley Napoli video on the basics of M&A, particularly focused on things that might be of interest to sellers. I'm pleased to be joined today by our new partner, Glavkos Tomboulis, who recently joined us in the M&A team at Kingsley Napoli. Hi Glavkos, thanks for joining me today. Perhaps you can do a little introduction.
Sure, thanks very much, John. Thanks for having me as well. Hi everybody. As John says, I'm a partner in the corporate commercial team at Kingsley Napoli. I've been practicing for almost 30 years now, and my practice areas encompass private M&A transactions, both on the buy and the sell side, and also joint ventures and other business alliances, and also with a particular focus on advising on corporate governance matters for corporate clients.
That's great. Thanks, Glavkos. And so perhaps we should just open with the question that people want answering if they've decided to click on this video, which is, what are warranties and why are they important?
Yeah, so warranties are very important, and particularly in the context of a corporate transaction. So if you're selling your business, you will be inevitably asked by the buyer to give warranties. And essentially what a warranty is a contractual statement made by the sellers relating to the state of the target group or company that you're selling, and also the business. So it's a statement of fact. It's in a series of statements which you'll be asked to give. And the reason sellers are asked to give those is because of the inherent information asymmetry between the seller and the buyer. The seller, obviously, sellers know their own business, they've been running it, so they're familiar with what's going on in it. The buyer is relying on the sellers to give the buyer assurances in relation to that business, which underpin the price that the buyer's paying. So that means warranties are actually a very important process for ensuring that there's a reallocation of risk, so that the buyer at least goes into the transaction with the confidence that it's received a bunch of statements from the sellers relating to that business, and that it's not buying something which it's overpaying for.
And if those statements prove to be wrong, then there's an opportunity to kind of adjust the price after the event through a claim for breach of warranty.
Yes.
And how do warranties differ from indemnities? Because you will, of course, see both in documentation.
Yes, that's right. I mean, again, just going back to the basics, a warranty, as I say, is a contractual statement about the state of the business. An indemnity is a very different creature of law. It's a very important distinction. It's basically a promise made by the sellers that that they'll reimburse the buyer or even the target for a specific liability. And that's an important distinction, because with an indemnity, if you were a buyer, you would typically ask for one if you became aware of an issue relating to the target business. The basic position under English law, if you're a buyer, is if you know about something that the warranty relates to, it's very unlikely that you're going to be able to recover if you bring a warranty claim, because you're already aware of the matter that constitutes the breach. In those circumstances, you would seek an indemnity, which is effectively a promise by the sellers to hold the buyer harmless for any liability. So you can see that the difference is a subtle one, but an indemnity is essentially a promise to pay the buyer where there's some kind of potential or actual liability in the target business. For example, there may be some kind of tax liability, there may be a claim that's brought by a customer or a supplier, and that's something which could crystallize into an actual liability, and that's what the indemnity is trying to protect against.
That's great, thank you. And just to help sellers understand what they'll be facing, when you look at an SPA, kind of how big would a typical SPA be overall, and roughly what kind of proportion of the SPA will be the warranties?
Yes, I mean, the SPA is essentially, but this is putting it very crudely, it's a document of two halves, essentially. You're going to have the front end and the warranties. The front end is the operative provisions which set out the price, any price adjustments, completion mechanics, and the boilerplate governing law, jurisdiction, confidentiality, all the kind of things that you typically see in an agreement. Then you look at the back part of the SPA, which will usually be set out in a series of schedules. One of the schedules will contain all the warranties. And on larger transactions, those can run into, say, 30 or 40 pages, and they can be extremely detailed. It's very rare that you'll see a arm's length negotiated M&A transaction without any business warranties. Sometimes happens if the parties all know each other and the buyer is very familiar with the business it's buying, but that's very rare. Typically, a well-advised buyer will always ask for warranties. So I would say that the warranties represent usually a significant proportion of the overall agreement.
And warranties are typically very heavily negotiated as well because they're allocating risk between the parties, and because they're trying to elicit knowledge, you need to make sure that they're not too broadly drafted so that the seller can't really answer the question or doesn't understand what he's being asked.
Yes.
From the buyer's perspective, you want it to be them to be able to actually make sure they're getting the information that they're looking for and something isn't missed. So there will often be, I know, long arguments about where warranty should be qualified by awareness, what awareness means, that kind of thing.
Yes, that's right. And I think the argument, kind of age old in terms of warranty negotiation, what typically happens is the buyer produces a first set of them, and they're usually very, very detailed and very comprehensive, and they're warranties that relate to all aspects of the business. The seller's response will be, we don't think all of these warranties are appropriate to our business. They're too detailed. This transaction is too small to justify such a broad set of warranties. The buyer's counter response will typically be, well, if there isn't an issue, then you shouldn't mind giving these warranties. You can just give them, and you shouldn't be concerned about there being a breach of them. So that's the kind of discussion you'll often have. And then it's an iterative process, but you'll sort of narrow down the warranties, and it'll sometimes come down to detailed drafting. Like some warranties will be subject to awareness or reasonableness or materiality. There's lots of devices that can be used to effectively bridge the gap between the buyer and the seller.
Okay, absolutely. And if warranties are breached, what are the implications of that? Obviously, there's going to be some kind of remedy for the buyer. That's the point. But how does it work?
Yes, that's right. So typically, what happens in the UK? If we're looking at a UK law-governed sale and purchase agreement, if there is a breach of warranty, the buyer will bring a claim against the sellers under the terms of the agreement. There'll be a notification of the claim. That will typically particularize which warranty has been breached, an estimate of the loss suffered by the buyer as a result of the breach. And so that would be the starting point. And in the UK, the way you determine what the loss is and what the level of compensation is essentially to put the buyer in the position it would have been had the warranty been true. And that's an assessment that a court will undertake just based on pleadings made by the parties and sometimes expert evidence in terms of what the damages should be. But that's the basis of determining what the level of damages are. And the buyer will have to prove that it suffered the loss and that it's the breach of the warranty that's resulted in the loss. So there are a few hurdles that the buyer will have to go through, which probably explains why warranty litigation in the UK is relatively rare, certainly compared to the United States, for example, where there's a lot more of that going on. And we can talk about that, John, if you like, as well. But certainly in the UK, warranty issues tend to get settled at an earlier stage by the parties because it's just often too costly and too complicated to actually proceed to trial.
Yeah, absolutely. We've actually done a separate video with our US colleagues from Leatherfield Pilstein on the difference between UK and US M&A, which people can find on our YouTube channel if they're interested in those questions. I certainly found it an interesting discussion. So I guess a couple of things to mention about how people might want to protect themselves when it comes to warranty claims. One is that the main protection, which is disclosure. So the sale and purchase agreement will contain the warranties as questions, and the disclosure letter is effectively where a seller gets the opportunity to provide answers. And if those answers are sufficiently clear, hit the required standard, which is set out in the SPA, then they will be protected against claims because they've answered the question properly. The second method that people can perhaps use to protect themselves is warranty and indemnity insurance, which is increasingly common these days.
Yes.
And again, we're going to do a separate recording with a warranty and indemnity insurance broker shortly, who will talk to us about some of those issues. But it's worth considering, and actually not terribly expensive these days. It depends on the business and the sector, but you are perhaps looking for a kind of standard commercial business at somewhere between 0.6 and 0.8% of the amount of insurance that's being paid for to protect yourself with warranty and indemnity insurance. So potentially worthwhile, particularly on a larger transaction where you want more certainty that you're not going to have to give money back.
Yes.
Glavkos, thanks very much for taking the time to talk to me about warranties. Obviously, this is a very quick introduction to the subject.
Sure.
We hope it's been useful for everybody who's listening. And of course, if you are looking to sell your business, or if you're looking to buy a business, please don't hesitate to get in touch with Glavkos or I. We'd be delighted to help you. Also, as I mentioned, we do have a YouTube channel. I think a lot of people come across these videos on our websites or via LinkedIn. But if you go to YouTube, there is the option to subscribe and like and all of that good stuff, which means that you'll see when we release further recordings which might be useful. So thanks very much, Glavkos.
Thank you.
Great. See you all later.